Welcome everyone to our sixth video in our Consumer Law for Individual Consumers video series, the Pro series. Our video today is entitled ABCs of Debt Defense, Part 2, Common Defenses. As always, I'm your course instructor, Attorney Aaron Swift. I'm the Swift Law North LLC CEO and Managing Partner. As always, we start with an agenda. Today we're going to begin with a disclaimer and some other disclaimers like usual, especially with these debt defense videos. We're going to talk about general versus affirmative defenses, common defenses, and then end, as always, with best practices. Again, this is not legal advice to anyone specifically or any group in general. These videos are only educational. This is not meant to give specific advice to anyone being sued currently or who is sued while or after watching these videos or purchasing. By watching and purchasing these videos does not guarantee any representation, nor is this legal advice with respect to any one specific issue, claim, or defense. As always, check your local and state rules, check with local legal aid, and maybe even check with the local courthouse. Some of them have some really good self-help resource centers, including even some on-staff attorneys that can help out for some low charges. Okay, let's get right in. So there's a big difference between general defenses and affirmative defenses. The common defenses I'm going to be talking about today are general defenses. These are basically general defenses to whether or not the debt is owed for various reasons. And it's different than an affirmative defense, which, for lack of a better term, basically admits the issues at stake in the regular case, but says there's other reasons as to why either the claim should fail entirely or in part. But again, I'm going to be talking mostly about general common defenses today as it relates to these lawsuits. You can find more information about affirmative defenses at other sources. There's some of them listed here. Latches, which is basically a timing issue, failure to mitigate damages. If there was an unreasonable sale, such as in a deficiency case for a vehicle after repossession, you now know about all those terms from previous videos. In some cases, debt collectors must register as debt collectors in certain jurisdictions to even be able to sue, and that can be a affirmative defense to the case that even though you might or might not owe the debt, their failure to register is a problem. And other things when the contract can be unconscionable and issues like that. But again, for the most part, we're going to be talking about general defenses. So again, this is not legal advice. This isn't specific legal advice with any one person or with any one specific defensive case, but generally speaking, these are some common defenses. So the statute of limitations, that's the SOL, that's how long someone can successfully sue over a claim or issue. So depending on the type of debt, you're going to want to be looking into what is the statute of limitations. In most cases, there might be a written agreement, like a card member agreement for a credit card, or a lease for a car, or a lease for an apartment, or a contract for sale for a car. In most states, there's going to be a statute of limitations for contracts in writing. Some states it's 5 years, some states it's 4, some states it's even shorter, 3 years. One of the interesting things that you can use as a defense is you don't just have to look at the statute of limitations in the state where you're being sued. It might also look at the choice of venue or choice of law provision in the contract, because that could have a state with a shorter period or a state with other protections. Another common defense is that, no, this has been paid, or there has been an accord and satisfaction, which is kind of another fancy way of saying it's been paid or settled. That would be a defense of these cases. Of course, if it's been paid or settled, that's a common defense. If there was fraud on the account and the person doesn't owe it, that's a defense to the entire suit. If a consumer was only an authorized user and not a co-maker or co-signer or co-debtor on the account, then that's a common defense you can use to say, I do not owe this debt. There's a lack of standing defense that happens a lot more when you're talking about junk debt buyers because of assignments. We talked about those previous video. If the alleged current creditor cannot prove that they own the debt, they don't have standing to bring the case. Similar, there can be defenses for subject matter jurisdiction. For example, if something should be arbitrated, then there's an argument that the court lacks subject matter jurisdiction. Courts have rules about certain amounts that can amount to subject matter jurisdiction, so you always want to look into that. One of the other defenses is you've been sued in the wrong place. We talked about that in various videos where you can use that as a defensive and an offensive measure. And sometimes there's other statutory defenses. If this is a case about an eviction or about alleged amounts owed in past due rent, you might have a case or to defend based on roaches or mold if it's a landlord tenant case. There's other examples of statutory defenses, but that's just one. Okay, so now that we've talked about the basics of these laws, you know, how they work, the stages of them, kind of some differences between small claims versus county court, whether you have to show up in person versus Zoom. It's still the best consumer best practice, which is just don't bury your head in the sand. Avoid judgments at all costs, especially default judgments. They're too hard to unwind. They give the creditor, the debt collector, the junk debt buyer too much power. If nothing else, contact your local legal aid. You may qualify for their services based on income or other, projects or grants. If not, they may have some resources to point you in the right direction, whether that's self-help or other local attorneys. Contact bankruptcy attorneys, even if it's not to file a bankruptcy, but that might be the best option. They might have good connections or referrals to someone in your state. And if all else fails, inspect the complaint and statement of claim against the details we've talked about. Raise some of these common defenses if they're appropriate. Look to see if these, the plaintiff in these lawsuits, whether that's a current creditor, original creditor, a junk debt buyer, see if they're reporting things wrong. See if they violated the FDCPA in the process. These are all going to be ways to use as defenses. And in fact, we're going to talk about in a future video how to use the FDCPA and FCRA as an offensive measure and even defensive measure in these cases more specifically. So, the best practice would be if you've been sued on the debt past the statute of limitations, contact us. That's one of the very good types of general and common defenses that can win a case. Attorneys are always interested in cases that they can win. Again, Swift Law North, its offensive program where it takes cases on the contingency fee basis, those are limited to the FDCP and FCRA. So debt defense cases are very different. There's a whole process involved with evaluating the case, but nonetheless, if you see grave errors that certainly relate to the case itself, or you just need help, reach out. We'd love to connect with you. For more information on an educational component, visit consumerlaw101.com, where we have more videos left in the Pro Series. And if you do have some issues that need to be litigated right away, especially if you have some winning common defenses in a debt defense case, reach out to us at www.swiftlawnorth.com. Thank you.